Hello and welcome everyone. I hope this message finds you fit and fine. We are in video number 42 in this Lakshmikant series, and today we are starting Supreme Court, one of the most important topic for prelims as well as mains. Let's start with the background of Supreme Court. Supreme Court is highest judicial court. We have a hierarchy in our judicial system: subordinate court at district level, then high court, state level, then Supreme Court at union level. It is final court of appeal. If I say that president is the final court of appeal in India, and you read a news that this person has filed an appeal before president against a judgment which was given by Supreme Court, would you say that statement is true, that president is highest court of appeal? No, because president is not having court there. Okay, it's not like there will be an advocate who is going to have some discussion on behalf of you before president. Just file is going to be submitted before president. So president is not highest court of appeal. It is Supreme Court. Okay. It is highest constitutional court. What is the meaning of constitutional court? A court which is having power to interpret Indian constitution. And why we are saying highest? Do we have other courts having this power to interpret our constitution? Yes, we do. High courts. So high court and Supreme Court, they both have power to interpret our constitution, but highest is Supreme Court. If High Court has interpreted something and Supreme Court has interpreted another thing, after that, then whom we are going to support or going to obey? Supreme Court's interpretation, obviously, right? So India is single and unified judicial system, and there are three-tier structure, as I told you: subordinate, High Court and Supreme Court. Now let's start with the history, background of this word Supreme Court. So there was Regulating Act 1773. We discussed about this in historical background of Indian Constitution chapter, right? Within this law, for the first time, Supreme Court was established. Means that the provision was there, and then Supreme Court was established in Calcutta. But please remember that Supreme Court was different from the Supreme Court we are having now. Okay? Because this was court of record with full power and function, but that function was not actually applicable to whole India, right? It was established to determine any suits actions for Bengal, Bihar and Odisha. Later, other Supreme Courts were also started. Yes, Supreme Court in Madras, Supreme Court in Bombay. So as of now, you know that there is one Supreme Court in Delhi, right? But there were other Supreme Courts which were established. 1800 Madras and 1823 Bombay. You need not to cram the facts, but you should know about the journey of this idea of Supreme Court in India. Then there was India High Courts Act. You should remember this particular fact because UPSC can frame a statement. A statement can be like this: Indian High Courts Act 1861 abolished Supreme Court at Calcutta, Madras and Bombay. Because I told you, separate Supreme Courts were established. 1773 as per that law in Calcutta, then 1800 Madras, then 1823 Bombay, right? So that was Regulating Act 1773, but it was actually established a year later. Okay. Now the point is, as per this act, these Supreme Courts were actually revoked. Okay, they were removed. And there was a time when these high courts were actually having this distinction of being the highest court. Okay, but in Government of India Act 1935, from this particular law, we established federal court. Okay, now this federal court, you can actually now familiarize with the concept of Supreme Court which we are having now. It means now this federal court is going to be above these high courts. Okay, so please remember this particular fact. There can be a statement on this in your exam. Now, since one or two questions are asked like facts of, so we are having this question: when was the Supreme Court of India first inaugurated? It was in January 1950. Okay, so it's not like you need to cram all the dates. Okay, now constitutional provisions. Where is Supreme Court situated in our constitution? It is in part 5 chapter 6, the union judiciary. Okay, part 5 is union, and within that chapter 6 is union judiciary. Article 124 to article 147, we talk about Supreme Court. There we talk about its organization, jurisdiction, power, etc. Now, Indian Constitution under Article 124 subclause 1 says that there shall be a Supreme Court of India constituting of a Chief Justice of India, and until Parliament by law make some changes, there will be 7 other judges. Okay, not more than 7 other judges. But since it is saying Parliament by law can actually increase the strength of judges, that is why our Parliament has increased the number of judges. The jurisdiction of Supreme Court of India can be broadly categorized into original jurisdiction, appellate jurisdiction and writ jurisdiction. They are quite simple. We are going to understand them logically. Organization of Supreme Court. So as I told you, we have a hierarchy, right? We have subordinate court, district level. So if there is a metropolitan area, there also we are going to have 2 branches, civil and criminal. In district, we have 2 branches, civil and criminal. Criminal matters are dealt here. We also call it sessions court. Then we have High Court and then we have Supreme Court. Now I'm making a statement. You have to tell me the statement is true or false. I've not explained you this. Okay, I'm just asking you so that you can become a bit more curious. Supreme Court has supervisory, or you can say supervisory powers over district courts or subordinate courts. That statement is true or false? Come on. I've not explained you this. I just want you to attempt, because there's a rule in psychology. When you are going to attempt wrong and I'm going to say this is correct answer, then this is going to be retained in your mind. So attempt. What do you think? Supervisory role, supervisory power. Supreme Court over district court. Some of you might think, sir, Supreme Court is the topmost court and you just told us unified judiciary. So it means Supreme Court must be supervising district courts. That statement seems true, right? But reality is that statement is false, because district or session courts, these subordinate courts, they come under supervisory jurisdiction of High Court. Means High Court supervise their transfer, postings, right? So this is called supervisory work. Okay, it is not under Supreme Court. And why? Because everything is having logic in polity. Why? Don't you think it is like adding burden to the Supreme Court's work if you give the supervisory work to Supreme Court? So many districts in India. Do you think it is logical? No. Now let's talk about strength. So as per Supreme Court number of judges bill, that it turned into act as well. Now the maximum strength can be 34. Okay. The Parliament is authorized to regulate them. Regulate what strength I'm talking about. Now let's talk about appointment of judges in Supreme Court. So judges are appointed by President, please remember. Okay, but the real twist is how. Because there's a debate there also. First we need to understand how it happens, then we are going to understand what is the debate there. Okay. So CJI is appointed by President after consultation with such other judges, judges of Supreme Court and High Court as he deems fit. Who deems fit? President deems fit. Okay. And is it really President using discretion? No. Council of Minister headed by Prime Minister. So it means when it comes to CJI, President is going to appoint what this provision is saying, but President is going to take into consideration the consultation from Supreme Court judges, High Court judges. Okay. But how it actually happens, we are going to talk about it. I'm just talking about what provision is saying. The other judges are appointed by the President after consultation with CJI. Okay. And such other judges of Supreme Court, High Court as he deems fit. So it means in case of CJI, we are talking about consultation. In case of other judges, we are talking about consultation with CJI. Now, please remember that in general, there is a convention by which CJI is appointed. Convention is seniority. The senior most judge in Supreme Court is appointed as CJI by Honorable President. Although there is no law in this regard. That is why this convention has been broken in past as well. We are going to talk about it. But you need to be aware of these nitty-gritties. What is written in Constitution, what is not written in Constitution, what is convention, what is not. Okay. So appointment of Chief Justice from 1950 to 1973, the practice has been appoint the senior most judge of Supreme Court as the Chief Justice. So this was the practice till 1973. Then came the change. In 1973, Mr. A.N. Ray was appointed as CJI, superseding these 3 senior judges. Who did that? So Indira Gandhi ji was having government. As I told you, president has to act on aided advice of Council of Ministers, and this happened. Okay. Again in 1977, M.U. Beg was appointed the Chief Justice of India by superseding then senior most judge. Now this discretion of government, don't you think it is like influencing the judiciary? Don't you think it is against the principle of independence of judiciary? Some judges may try to actually give some judgment in favor of government in order to get this plum plastering. So this should not happen, right? So how this evolved? The discretion of government was curtailed by Supreme Court in second judge's case. So now Supreme Court actually pronounced judgment so that this concept of independence of judiciary can be actually protected, in which Supreme Court ruled that senior most judge of Supreme Court alone, please remember, alone, can be appointed to the office of CJI. So now it's not just a convention. Now senior most judge of Supreme Court is going to be appointed as CJI because Supreme Court made this judgment in second judge's case 1993. I think it is clear. Now, who among the following was the first woman judge of India? This is a factual question. Ms. Fatima Bibi, you should know about it. Which of the following statement is not true about India's Supreme Court? Not true, you have to tell, okay? Article 124 to 147, Part 5 of Indian Constitution informs the composition and power of Supreme Court. Supreme Court was inaugurated on January 28, 1950. The first female CJI was from Karnataka. The statement is false. The reason is, till now, we did not had any female judge as CJI, okay? But soon we are going to have in 2027, okay? You have to mention the name in comment, okay? This was in news. Judges of Supreme Court are appointed by President of India. So these three statements are correct. This is wrong, and you have to tell not true, okay? Controversy or consultation. So first we talked about provision. Now controversy and how the system evolved. Now we are using the word Collegium system. So this word Collegium, what does it mean? It means who is going to be appointed as judge. Obviously, is going to be decided by president, but someone has to give the name before president. Who is going to give that name? So now judiciary is going to give that name, obviously, because provision says consultation. So now this consultation is more organized now in the form of this collegium system. Supreme Court has given different interpretation of the word consultation. Now, as I told you, president should consult senior most judges of Supreme Court, High Court as he deems necessary, deems fit, right? So now this consultation, is it mandatory or it just advisory? So our constitution has not elaborated on that. So now what Supreme Court said? In first judge's case 1982, Supreme Court said actually this consultation is not mandatory. It means the court held that consultation does not mean concurrence and it only implies exchange of views. What does it mean? It means government, means Council of Ministers got more power than Supreme Court. Why I am saying that? Because Council of Ministers can advise President that we need not to listen to the consultation or advice given by this collegium or these group of judges. Okay, because consultation does not mean mandatory or concurrence, right? But later, in the second judge's case, 1993, the same judge's case which talked about this appointment of CJI based on seniority. Now, what it said about this consultation interpretation? The court reversed the earlier ruling and said, change the meaning of the word consultation to concurrence. Concurrence means no, president cannot appoint someone on his own. Means consultation, you have to concur with the consultation. So what does it mean? It means now Supreme Court. I am using the word Supreme Court so that you can relate to the word judge, okay, collegium, okay. Although in this collegium there can be High Court judges as well, okay. So now means power, or you can say ball came in the court of judges, right? In the third judge's case 1998, the court opined that consultation process to be adopted by Chief Justice of India requires consultation of plurality. Now, what does it mean? As I told you, in the second judge's case, one thing was clear, that the recommendation or consultation of this judges, it is mandatory. You have to concur with that, You cannot actually randomly pick and choose anyone as judge who is not actually given this recommendation by these group of judges, okay, whom we are calling Collegium. But now the point was, in this Collegium, there is CJI and the other judges. So what if CJI is recommending one thing and other judges were actually not agreeing with that? Whom we are going to consider consultation as concurrence? CJI's authority or CJI's recommendation will be superior than others. So on this third judge's case said that, no, CJI requires consultation with plurality. And what is the meaning of plurality? It means CJI should consult other judges as well. And if other judges, for example, more than 2 judges are saying, no, we are not agreeing with the name, then CJI cannot recommend that person's name to the president that please appoint that person as Supreme Court or High Court judge. The sole opinion of CJI does not constitute consultation process. This is third judge's case. He should consult a collegium of 4 senior. Now, after this third judge's case, the word collegium, its structure became more clearer. He should consult collegium of 4 senior most judges of Supreme Court, and even if 2 judges give adverse opinion, as I told you, if 2 judges are saying no, we should not actually recommend this person as Supreme Court judge, then CJI should not send recommendation. And even if CJI send recommendation, then government, or you can say Council of Minister advising president, they can actually say no, we are not going to concur with this, because consultation equal to concurrence is only when CJI consult with the other judges as well, right? And in this consultation, there's more than 2 should not actually disagree. So that is why recommendation made by Chief Justice of India without complying with the norm, this is the norm, required consultation process are not binding on government. That won't be binding. Clear? Now lawmakers and contestation. Now there has been this debate that collegium system is opaque. Many times, see some senior most judges of Supreme Court and High Court, their son and daughter, they also are recommended by collegium, whereas there are many other first generation judges as well, but they don't get due chance. These are kind of allegations. So it means this opaqueness should be removed. On this, NJAC was actually introduced by Parliament. So they amended the constitution and they brought this NJAC, National Judicial Appointment Commission. And in this NJAC, I think it is visible to you, in this composition, they also added Union Law Minister. So it was CJI, 2 senior most Supreme Court judges, Union Law Minister, and 2 eminent persons. So now, judiciary said no, you are adding 2 eminent persons, you are adding Union Law Minister. It is like executive is having say in deciding who is going to be judge in Supreme Court. So judiciary said this is against the principle of independence of judiciary, and that is why this NJAC was declared null and void. So this idea of bringing transparency in this appointment of Supreme Court judges, this was declared null and void. So now we don't have any NJAC system in India. But since it was a part of debate, that's why I've brought up here. This PDF will be shared in my Telegram group, Shashank Tyagi for you. You can pick up from there. If you have any doubt whatsoever, you can shoot me a message on shashank.powerbean. That is my Insta handle. A person to be appointed as judge of Supreme Court, what qualifications that person should have? That person should be citizen of India, number 1. Apart from this is a mandatory. Now, from these 3, so there should be at least one condition which should be met. That person should be judge of High Court or High Court for 5 years. Okay, you should be judge of High Court for 5 years. If you're not judge of High Court for 5 years, you should have actually followed the second condition. He should have been an advocate of High Court or High Court in succession for 10 years. Okay, advocate in High Court for 10 years. Even if you are not fulfilling this condition, then you have third option. He should be a distinguished jurist in the opinion of President. President should declare, oh, this person is a legal luminary. That person is a legal researcher and that person has contributed in our law making process or interpretation of law in India. So on this basis, you can also be considered for this position of judge, right, in Supreme Court. Now the Constitution has not prescribed minimum age. Please remember, Constitution has not prescribed any minimum age for the judge of Supreme Court. Okay. But these conditions are such that themselves actually make sure that only a person who has achieved this much feat is going to be there. So it is going to take some time. Now oath and affirmation. So it is given by President. Tenure of judges. So there's no time limit. There's no 5-year, 6-year tenure to the Supreme Court judges. What happens? They can be in this position for the maximum time of 65 years. If you are appointed at 62, it means you have 3 years remaining. If you are appointed at 60, then you have 5 years remaining. He can resign office by writing to the president. So president gives the oath and you can write resignation to the president. He can be removed from your office by president on the recommendation of parliament. So there is a process there. How removal happens? UPSC has asked question in prelims. So this is the stage. Number 1. So if you want to start this removal process of Supreme Court, High Court judge, you should actually have at least support of 100 members in case of Lok Sabha, 50 members in case of Rajya Sabha. Consider you have a letter on which 100 members have supported. Now you need to present this letter before Lok Sabha speaker. If you are in Rajya Sabha, you need to take a sign of 50 members saying, no sir, we have some proof against this particular judge. We want this removal of judge. So this matter need to be referred to chairman of Rajya Sabha. After that, if speaker chairman accepted, please remember the word is if means there's a possibility. You have the sign of 100 members and you have presented before Speaker Lok Sabha, sir, we want removal of this Supreme Court judge. It may be possible that speaker says, no, I'm not agreeing, I'm not accepting your recommendation to actually start this removal process. So that is why if word is used. Please remember UPSC play these kind of tricks. Then if they accept a speaker or chairman, whichever house you are taking up in, then 3-member committee will be constituted who is going to investigate the charges. Committee investigate the charges and they are going to see whether that person is guilty of incapacity or misbehavior. And if they found, now the process of impeachment is going to start. Although some book says that impeachment word should be used for the removal process of president only, there are other books which also use this impeachment word for the removal of Supreme Court, High Court judges. So point is, after this committee has investigated, found the charges valid, then this process is going to start. Then motion must be passed by special majority in the first house. Then this particular motion will be presented to the other house, and other house also it need to be passed by special majority. Okay, and when it is passed by both houses, then motion is presented before president. As president signs on this, then it is considered that this judge is removed. As of now, in our history of independent India, no judge has been removed by this process. Okay, no impeachment happened. Now we have a question relating to this particular subtopic. Just attempt. Consider the following statements. You have to answer which statements are correct. The Judges Inquiry Act 1968 regulates the procedure relating to impeachment of judge. The president can issue the removal order only after an address by parliament has been presented to him in the same session for the removal. Same session. It means, consider this process started in, say, winter session. Okay. And it was passed from Lok Sabha, but somehow when it was presented to Rajya Sabha, it could not be taken up, and then session actually ended. Now can Rajya Sabha take up the same motion in the next session and get it passed and then get it presented to president, and president sign, and that person will be considered removed. The judge will be considered removed. Or you need to get it passed in the same session. If it is a monsoon session, get it passed from the both houses in the same session. If it is not passed from the same session, then you have to start it again. Okay. So this is the meaning of the second statement. Now, the address must be supported by absolute majority of each house. As I told you, it is a special majority. It's not absolute majority. The statement is wrong. So far, 2 judges have been failed to impeach, and 1 impeached in Supreme Court of India. This statement is wrong. I've just told you no one has been impeached till now. So it means 1 and 2 statements are correct. It means A is the answer. Clear? So this is the explanation. This will be available in your PDF. Acting Chief Justice. What is the meaning of this? Consider, Chief Justice of India has vacated office. It may be resignation, death, or removal. Then you need acting Chief Justice. Who is going to appoint acting Chief Justice? Who is going to appoint? President. Please remember, President. Chief Justice of India is temporarily absent. For example, Chief Justice of India is on, say, on medical treatment, that he's in coma or something. So in this case also we need acting Chief Justice, right? President is going to appoint. Chief Justice of India is unable to perform duties. It may be possible. So in this case also, President has to appoint acting Chief Justice. Then we have ad hoc. Ad hoc means temporary. Consider, we need a bench. Bench means in Supreme Court, decision on a particular judgment is not taken by one judge. There's a bench of 3, 5, etc. So there's a shortage of judges at that point of time, and one bench is having just 2 judges and we need one more. So temporary arrangement can be done. When this lack of quorum, we call it quorum, means minimum strength which is required. For example, 3. Then, and because there is shortage of permanent judges. So in this case, Chief Justice of India can appoint a judge of High Court, as ad hoc judge in Supreme Court for a temporary period. Ad hoc means temporary. But for this, you need to actually consult with the Chief Justice of that High Court, because you are giving additional work to a judge of High Court, right? So you need to take permission, consult with that Chief Justice of that High Court. Consult word needs to be used, and you need to take permission. You need to keep into, you can say, loop President of India. So after consultation with the Chief Justice and concern with the President. So Chief Justice of that High Court and President should be kept in loop. Then only CJI can appoint a High Court judge as ad hoc judge in Supreme Court. I think this trajectory is clear to you. Judge so appointed should be qualified for the appointment of Supreme Court judge. For example, that if a High Court judge, if a person got a position of High Court judge six months back, can that person be appointed as ad hoc judge? No. At least you should be qualified for becoming Supreme Court judge. For example, in the appointment criteria, what I told you, in case of High Court judge, you need to be High Court judge for at least 5 years, right? So a question can be actually played at this point. Judge so appointed attend the sittings of the Supreme Court in priority to the other duties of his office. While so attending, enjoys all the jurisdiction, power, privileges during discharging his duty as Supreme Court judge. Now retired judges, can they be actually taken into job again for temporary period? Yes, there's a scope. CJI can request a retiring judge of Supreme Court or retired judge that we have a shortage of judges and we need your work, your contribution. So at this point, that person can also be given some position. He can do so only with the previous consent of the President and also with the person to be appointed. So President should be kept in loop. Now procedure of court. So what does it mean? Means how actually court work, what kind of judgments or what kind of powers it is having. For example, Supreme Court wants some new rules. So can Supreme Court make its own rules? Yes, Supreme Court can make own rules or own procedures, but in this case, approval needs to be taken from President. Okay. Constitutional cases or references to the President under Article 143, we are going to talk about it. The purpose is that there are certain procedures. For example, all the cases are usually decided by bench consisting of not less than 3 judges. Okay. When there is a case of advisory jurisdiction, President has referred a matter that need to be taken up by 5 judges. As I told you, 3, 5, right? So odd numbers are the numbers of judges on a bench on Supreme Court. Why not even? Why not 4, 6? Because there will be a tie, right? If there's odd, so majority, actually the support of the majority is going to decide the judgment of Supreme Court from that bench, and that is why odd numbers are taken in the Supreme Court benches, not the even ones. Now Constitution has made following provisions to safeguard and assure independence of judiciary. So what are the points? For example, mode of appointment. In mode of appointment, judiciary has a say, concurrence, consultation, security of tenure. You cannot remove Supreme Court judges arbitrarily. There's a process. We just talked about it. Fixed service conditions. Parliament cannot change them when that person is already a judge. Expenses charged on Consulate Fund of India. It means you cannot vote again and again every year how much you need to give to the Supreme Court judges as salary or pension. You cannot do that. Conduct of judges cannot be discussed. Okay, charge on Consulate Fund of India, I told you about in Parliament chapter as well. It means this much amount need to be given and this will be given. Okay, you need not to vote it during the budget. Right? Conduct of judges cannot be discussed in Parliament until unless there's a removal motion which is in place. Okay, so that you can uphold the dignity of this court. Ban on practice after retirement. You cannot practice as an advocate after retirement, so that there's a transparency there. Power to punish for its contempt. If someone does not obey, or you can say attempt to you can say demonize, or you can say spread such news which hampers the dignity of the court, then such contempt can be leveled. I hope you remember there's a case of Mr. Prashant Bhushan, advocate in Supreme Court. There was a contempt court which was going on. Freedom to appoint its staff, its jurisdiction cannot be curtailed, and separation from executive. So these are the, you can say, provisions which make sure that Supreme Court can work in independent manner. Now, these are the important sections within Supreme Court. Original jurisdiction, advice jurisdiction. Supreme Court is a court of record. It means decisions binding on other courts, court as a court of record, as well as highest court of appeal, as well as writ jurisdiction. So these are the jurisdictions of Supreme Court. We are going to talk about them in a step-by-step manner. Okay. First of all, original jurisdiction. It simply means the matter can be taken up at the level of Supreme Court directly. For example, if there is a matter between center and state, center versus state, if they are having dispute, they can take up directly towards Supreme Court. If there is a dispute center plus state versus some other state, original jurisdiction. Third case, state versus state, original jurisdiction. Means these disputes can be taken up directly to the Supreme Court. That is why they are called original jurisdiction. But there is another word, exclusive original jurisdiction. What does it mean? It means matters which can be taken up only at the level of Supreme Court, only. So let's attempt this question. Then we are going to expand it further. Consider the following statements. Matters referred to Finance Commission, interstate water disputes, dispute arising on any of treaty agreement, certain expenses, dispute arising of any pre-constitutional treaty agreement. Which of these does not come under original jurisdiction of Supreme Court? What does it mean? It means matters which cannot be taken up directly at the level of Supreme Court. I hope you remember our discussion in center-state relations. I talked about, for example, interstate water disputes. What our constitution says, there will be a tribunal, right? And the decision taken by tribunal will be final, right? This need not to be taken up at the level of Supreme Court. You cannot take up this matter directly to the Supreme Court because there is a tribunal. So our constitution says that, right? So now I hope you are relating. It means this matter is not going to come under original jurisdiction. So there's a list. Original jurisdiction of Supreme Court does not extend to the following cases. I hope this is visible to you. Let me zoom in a bit. For example, if there is a dispute related to some interpretation on pre-constitution treaty. What is pre-constitution treaty? A treaty which was signed during Britishers' time. Yes, they are applicable even now. So if there is a dispute, okay. For example, there is a dispute on a pre-constitutional treaty between Kerala and Tamil Nadu regarding Mullaperiyar Dam. So that is pre-constitutional treaty example. Agreement, covenant, sanad and other instruments. So they are not coming under original jurisdiction. It is not they are going to be directly taken up at the level of Supreme Court. Any dispute arising out of any treaty, etc., specified, specifically if that treaty is providing this matter will be taken up by this jurisdiction, said jurisdiction. It may be tribunal, right? Interstate water disputes can be taken up tribunal, right? Matters referred to Finance Commission, adjustment of certain expenses, pension between center and states, ordinary dispute between of commercial nature between center state, recovery of damages of a state against center. When I say they are not coming under original jurisdiction, it means they cannot be taken up directly at the level of Supreme Court. When I say exclusive original jurisdiction, it means this matter need to be taken up directly at the level of Supreme Court. Okay. Now, let me give you one other example so that this becomes much more clearer to you. Take example of writ. Writ issued by Supreme Court related to protection of fundamental right. Okay. Tell me, if a statement is being asked by UPSC, that writs for protection of fundamental right, they come under exclusive original jurisdiction of Supreme Court. That statement would be true or false? That statement would be false. You know why? Exclusive nahi. That is original, means can be taken up directly at the level of Supreme Court, but not exclusive. Why? Because this writ can be taken up by using Article 226 at the level of High Court as well. By using Article 32, it can be taken up at the level of Supreme Court. So it means it will be considered under writ jurisdiction as well as original jurisdiction of Supreme Court. Can be taken up directly at the level of Supreme Court, but not exclusive original jurisdiction. Okay, because why not exclusive? Because it can be taken up at the level of High Court as well. I think it is clear now. So writ jurisdiction. Supreme Court is empowered to issue writs including habeas corpus, quo warranto, certiorari. We discussed about them. In this regard, Supreme Court has original jurisdiction, as I told you. Explained already. Can go directly to the Supreme Court. However, writ jurisdiction of the Supreme Court is not exclusive. Already explained. High Court are also empowered to the issue such writs. That is what I have explained this to you, right? If I say writ jurisdiction of High Court is much more elaborate than writ jurisdiction of Supreme Court, that statement would be true or false? Come on. Statement would be true. You know why? Because High Court's writ jurisdiction, High Court can issue writ for fundamental rights as well as legal rights. But in case of Supreme Court, as per Article 32, Supreme Court is empowered to issue writ for protection of your fundamental rights only. Okay? Now attempt this question. Which of the following statement is not true? You have to identify not true. Supreme Courts can issue writs that relate with only fundamental rights of citizens. High Courts can issue writs on issues that relate with fundamental rights as well as other reasons. The jurisdiction with regard to writs is wider for the High Court as compared to Supreme Court of India. Writ jurisdiction of Supreme Court can be extended by Parliament but never decreased. All statements are correct. Parliament cannot decrease, but Parliament can increase writ jurisdiction, right, of Supreme Court. Clear? Appellate jurisdiction. The word comes from the word appeal. If you're not satisfied with the judgment of High Court, you can go to the Supreme Court, right? So appellate in which cases? In constitutional matters, means it is related to interpretation of constitution by High Court. For example, in case of this IPC section 377, I'm talking about homosexuality. So that matter was appealed from Delhi High Court to Supreme Court because that was an appeal in constitutional nature, because some people said it is against Article 21, right? Means right to life and personal liberty. Matter related to civil matter, appeal related to criminal matter, appeal related to special leave. What is special leave? Can anyone tell me? In comments. So special leave means, for example, High Court. So if High Court has pronounced a judgment and you're not satisfied with the decision of High Court, you can actually appeal to Supreme Court, right? But there's a process there. If you want to appeal to Supreme Court, you want to use this appellate jurisdiction of Supreme Court, you need a certificate from High Court. If High Court thinks that your case is not worthy to be sent to Supreme Court, and High Court is not issuing you the certificate on the basis of which you can appeal in Supreme Court, then what you consider? Means doors are shut in Supreme Court for you? No. So in this case, you can use the special leave, as the word says special leave. In this case, you will present an affidavit before Supreme Court saying, sir, I have not got permission from High Court, I have not got the certificate, but I want my case to be actually heard at your level. So in this case, the Supreme Court Secretariat is going to decide whether to accept your special leave petition or not, whether to accept your case or not. Means discretion is with Supreme Court whether to accept or not. But if certificate is issued, then Supreme Court has to accept. Supreme Court has to at least listen once. Okay. So I think it is clear now. Advisory jurisdiction. As the name suggests, advisory. So as per Article 143, President can seek advice from Supreme Court on two matters. One, if there is a matter of urgent public importance arising which is likely to arise, or any dispute arising of pre-constitutional treaty, agreement, covenant, engagement, etc. In this case, there is also a twist. Twist is, in case of advisory jurisdiction, Supreme Court is bound to give advice to the Honorable President in the second case. but not bound to give advice to Honorable President in the first case. You would say, oh, such thing can happen. Yeah, this happens. And there's a logic behind it. Consider the case of Babri Masjid. So before the final judgment by Supreme Court, this was a matter, urgent, important matter, right? There was a huge debate going on. In this case, if President use Article 143 and seek advice from Supreme Court, what's your opinion? What should happen in this case? Then Supreme Court can say, sir, though it's a matter of public importance, but we are not going to give you advice because matter is already under sub judice. And if we give you our advice and it becomes public, it means the judgment is already done. Why wasting arguments there, right? We cannot put the matter out till we actually listen to all the arguments. That is why we are unable to give you such advice. But in second case, you are bound to give advice. Now my question to you, as per advice jurisdiction, the advice given by Supreme Court to the Honorable President is binding on Honorable President. It is true or false? Answer is false. It is not binding. It is just an advice. So advice given is not binding on President. Clear? Court of record. It simply means the decisions which you take are going to set legal precedents and legal references by the other courts. Okay, means other courts, means high courts and other courts are going to refer your judgment, and on this basis they are going to pronounce their judgment. High Court and Supreme Court both are court of records in India. Okay, it has power to punish for contempt of court as well. Power to judicial review. Our Supreme Court can judicially review our legislative action, executive action. They are going to see whether it is in consonance with the provisions of Indian Constitution or not. If not, then this can be declared ultra vires or null and void. So I hope now this part is a bit clearer to you, right? And you are well aware of the twists and tricks, the traps which UPSC lay for students, right? So now, see you in the next video then. Keep learning, keep growing. Shashank Tyagi is signing off. If you have any doubt, you can shoot me a message on shashank.powerbeing. That is my personal Insta handle. This PDF is going to be available in this group. See you.